Justice Served is happy to welcome Gene Rossi, my friend Polenta Gene, but he's more than just my friend because he has tried so many cases. He has a room at the Justice Department named after him, a war room, and he has been following the Trump trial, and that's what we're going to talk about today, Michael Bryan with Gene Rossi. Gene, want to get your thoughts right off the bat.
You know what? I think of a baseball game. This is we're probably in the seventh inning, maybe the sixth inning.
You keep talking.
And I think that this week the prosecution did not have its best week. They were shooting for a home run with the bases loaded, and I think they may have struck out. Although at the end of the day, all they need to prove is that there is a Stormy Daniels. She did have a story, whether it's 100% true or 100% false, and that Mr. Cohen and Mr. Trump were very afraid that this story, true or false, would get out. That's the heart of the case. And they got to connect it to the invoices. And if they don't connect it to the invoices, Donald Trump will be acquitted. It's as simple as that.
Okay,
it's a very simple case.
Here's my challenge.
It is a simple case.
It is a simple case, and it's actually a boring case. I mean, I do complex business litigation, and they're the most boring cases ever. They're paperwork cases. They're paper cases you would never put in front of a jury. If it were a civil matter, as this really is an underlying case, it's a civil matter. The judge would be the one making the decisions, and all this salacious stuff would never happen. But this is a very different version of that kind of case because of the players involved. So
yeah.
So what concerns me is with this particular case and the way it's playing out is it's not going to matter whether some of the stuff that came in, especially through Stormy Daniels, which the judge admitted, maybe that shouldn't have come in, but I'm not going to grant him this trial.
Michael, can I just stop you there?
Wait, let me just get to my question.
Wait, objection. Okay, I'm finished.
Okay, thank you. Let me get to the question. The question is, does it really matter whether he is convicted or not? Haven't those who wanted him sitting in that chair, in that courtroom during this kind of important time leading up to an election, haven't they done what they needed to do? Hasn't the purpose been served?
I agree with you. If he is acquitted or if it's a hung jury, he should have a parade. The Trump people are going to probably make it, Liberation Day. But if he is convicted of any number of counts, whom will it affect in terms of voting? It won't affect the core people who are MAGA supporters. Okay, he could shoot somebody on Fifth Avenue, and he could claim self-defense, and they would believe him. All right, he could even claim, a heat of passion, and they'd still vote for him. The people whom it will affect, in my view, is that very narrow, independent Nikki Haley Republican, a Democrat that really doesn't like Biden, but maybe leaning towards JFK or Trump. It may affect that. And even if it only affects 1 or 2% of the vote, that could be the election. So if there's a conviction, I can't see how that's a net plus for Donald Trump. I can't. If it's an acquittal or a hung jury, game over. He's going to have a parade. He'll have fundraisers celebrating. It'll be a bad day for the Biden folks.
Yeah, it'll be, as I said to one TV network, you just put him on like a wheelbarrow and wheel him into the house, right, with everyone around him and all. But the reason why I interrupted Michael is the other day the prosecution hit those guardrails, right, and it almost went over. But the defense attorney also had the word objection. Hello, 101, teaching at Harvard.
Let me tell you what I would have done, okay? We all know what a speaking objection is. It's frowned upon. It really antagonizes judges. Some judges allow it, actually. But a speaking objection for the audience is when you stand up and you basically give an argument, closing argument as to why this evidence is bad in terms of evidence. There were 2 or 3 occasions when the attorney should have just stood up and for 2 full minutes, while the judge is telling a person to sit down, just put on the record how outrageous it is, how salacious this is. And this is going from a invoice case to the National Enquirer and Penthouse, and it's becoming a joke. And I would say the word joke to the judge. He would have a sidebar, but I made my point that her testimony about some of the stuff was stupid. And here's whom I blame, not just the defense attorneys who were asleep at the switch. I blame the prosecutors. I wonder how many times, folks, they prepped Stormy Daniels. I wonder how many times they prepped her. Number two, when you did prep her, did you read her the riot act and say, this is how you have to act in terms of your demeanor? You have to show respect to the court and you can't go off at tangents. And third, here's our areas I'm not going to be asking you about. So don't volunteer these answers. And that's all permissible prep comments to a witness. So don't volunteer these answers. And that's all permissible prep comments to a witness.
Do you think that today she rehabbed herself? I thought that her testimony today was excellent. I don't know, Michael.
You know what? My wife, the great Diane, she's my eyes and ears. I couldn't watch. She brought up the same point you did, Linda Polenta Kenny Bodden. Okay, the only person I know who likes plain polenta. Okay, let me repeat that. The only person in America who likes plain polenta. I digress. But what Diane told me is what you just said, Linda, and I say this with affection. What you just said is right on the mark. And here's what happened. In the first 2 days, pigs get fat, hogs get slaughtered. The prosecutors got ahead of their skis. They did something stupid by letting a witness talk about stupid stuff. What the defense attorney did, I think Tuesday, was a really effective cross, narrow, focused, punchy. And I think what happened between Tuesday afternoon and Thursday morning is this. The bear in the room, the guy with the biggest ego, the stable genius, told the attorneys, or told that attorney, I want you to cut her to shreds. That's what I think happened. He instructed her, I'm paying you, you cut her to shreds. And I've heard that they were yelling at each other, talking over each other, and Stormy got in some real zingers. There was one about pornography. You obviously don't know what pornography is or something like that. I mean, that's stuff that makes the jury laugh. And as you guys know, if a jury is laughing with a witness, that is good for the prosecution.
Mm-hmm. Yeah, we know that she attempted that day one to kind of say some things offhand that were lighthearted, and the jury, I guess, was stone-faced about it. She's definitely a tough-to-control witness, no doubt about it. Maybe he's bad, and maybe not as bad as Trump, but goes off. If a yes or no answer is called for, that's not good enough. She likes to explain. Let me ask you something. Let me get your reaction to this. I consider this an interesting irony, and it has to do with Mr. Davidson, who you worked with, right, years ago?
I represented him in 2018, a little bit of 2019.
So here's what I think is ironic. He's on the stand, and he's testifying about a text that was written after the deal carried out with Mr. Cohen, the $130,000, and he says something like, "What have we done?" That was the quote. And he went on to explain during his testimony that they were concerned that maybe they helped get Donald Trump in the White House by covering up this story. So now I find it ironic that now he's testifying in a trial that in a way could also help Donald Trump get back in the White House. What do you think about that?
This whole case, the last 9 years, has been one total irony when it comes to Donald Trump. I will say this. Based on his public testimony and public filings and public comments he made before and during the trial, it is clearly apparent that in Keith Davidson's mind, he felt that this deal could kill his candidacy. And he knew, because he was representing Stormy, he knew that if this had been brought out in 2013, nobody cares. But this was hitting that strike zone in baseball. That wheelhouse. He knew that the week before the election, 2 weeks, that his client could hit a home run and the bases loaded. And here's what is not being brought out, maybe brought out in closing. Nobody's talking about it except Gene Rossi. There are two pieces of evidence that if I were in closing for the government, I would pound. One, in the December 2018 sentencing memo filed by the Southern District of New York prosecutors, with whom I met, all four, with my client. They were brilliant. They filed a sentencing memo. Footnote 11 of Cohen's federal sentencing memo has a piece of evidence that I would pound if I were a prosecutor. What is it?
What is it? I'm dying.
In 2013, the Federal Election Commission was investigating Cohen and Trump for an improper in-kind contribution. Why? Because Donald Trump in 2011 was thinking about running for president against Romney et al. That's why he came up with this racist birther thing, because he wanted to get into the primary. He never got in because he got cold feet. But during that testing the water period, Cohen paid, wrote a check, credit card, paid for either a poll and/or an online site for Trump. Trump's thinking about president. That is an in-kind contribution if it is not reimbursed by Trump. So the FEC was looking into that. Why is it important? Because Trump and Cohen, according to the footnote, they were just slapped on the wrist. They're on notice what an in-kind is, what the limits are. They are familiar with the nuances of FEC rules and regulations. Fast forward to October. It's stating the obvious. According to Cohen, we didn't want to put this on the books.
So why aren't they using it?
And why didn't the Election Commission or the DOJ do anything about it prior to this?
Now, we don't know yet if they're not going to put that footnote in. We don't know this. And we also don't know if Cohen doesn't talk about it. If they don't bring it out through Cohen's testimony, then in 2013, they got a slap on the wrist because he violated in-kind contribution limits. If he doesn't talk about that, and if he doesn't say, hey, Trump was all aware of that one, that's malpractice on the part of the prosecutors. The second thing is this. In August of 2015, the prosecution's argument is the conspiracy scheme was established. It's a four-legged stool. One leg, catch and kill. We know what that is. Second leg is print good stuff about Trump. Third leg is spread intentionally defamatory information about Cruz, Dr. Carson, and Hillary. Fourth leg, and this is the hardest, the fourth leg is we got to find a way to conceal it, i.e. the invoice. Now, all four legs were not put on the same time, but those are the four legs. This is evidence that the scheme was still active and it was effective. That NDA, members of the jury, that NDA, you look at it, it's Exhibit 38. Who signed it or whose name's at the bottom? Of course, they're fake names, but it's Stormy Daniels, and the other person is Donald Trump. That NDA is between two people. This NDA does not say anything about prohibiting the National Enquirer from publishing it because they knew about it. They don't care about the NDA. If they know about it, they can print it. And guess who did not print the Stormy Daniels story in the last 2 weeks? The National Enquirer. And David Pecker said he cares about money. If the National Enquirer had put this on the front page of its magazine or whatever they want to call it, 10 days before the election, they would have made $50 million in an hour. They didn't. The absence of action, the omission, members of the jury, is strong proof that that scheme was still active because Pecker did not publish that story. That's what I would argue.
Okay, let me. I'm sorry, Linda. I got one quick question here because you mentioned the conspiracy. You're talking about a scheme, and we've heard so much in opening statements and in other arguments about a conspiracy. There's no charge of conspiracy in this case.
Yes, there is.
Where is it?
Well, if you look at the indictment, it charges the scheme. But in a sidebar, I think 2 weeks ago, the prosecutor, from what I heard, told the judge that one of the crimes that they're alleging as part of the scheme is a conspiracy to violate election laws.
Right. I read that.
But that was as a sidebar discussion outside the confines of the indictment. So are they going to bring some motion to conform the indictment to the evidence presented?
Well, no, because in the indictment it says to violate laws, and I think it says federal and state laws. I don't have it with me.
Right. It does. It just does.
Yeah, and here's the other reason why it's got to be a conspiracy. Okay. The statements of conspirators are coming in left and right like a wheelbarrow. Okay? You'll have a witness on the stand and they're quoting a conspirator. And as you know, it has to be in furtherance and during. But they're quoting conspirators left and right. There's no objection. So that's further proof that it is a conspiracy. Last thing is, a scheme under the case law is kind of a conspiracy. Kinda.
Well, let me ask you this, Gene. One of the reasons why I think Stormy Daniels did well today is, quite frankly, I was kind of offended by going after her. You know, this almost like the old sex slut shaming stuff.
I'm glad you said
I don't want to say poo poo because we're a family show here. But I really was offended by it, and I think that we're in a different age than go after her because she was wearing short skirts. Go after her because she's made porn movies. Go after her because they were trying to say you did sex clubs. She said, I don't do sex clubs. I do strip clubs. There's a big difference. And I just thought that was, you had some cross-examination. You didn't do it right.
Pigs get fat, hogs get slaughtered. I had a couple of drug cases where I called them, like in the front of the jury, I called them ladies of the night. All right. When they took the stand, I treated them like they were Miss America. Okay. I didn't shame them. I just said that you would provide services for money, physical, and instead of calling it sex, I used to say, and with Gene Rossi or your client, you would get busy. Okay. And I wouldn't get into details because I showed respect for them, even though they were ladies of the night. But the juries loved them. They loved them because, people go to a religious, people go to church on Sunday, not because they're saints, because they're sinners. And jurors are the same way. They know people aren't perfect. So they made Stormy Daniels likable by what you just said. Maybe not likable, but sympathetic. Sympathetic.
I don't disagree. I do think that as far as Stormy Daniels is concerned, she's in a little different category. It's not like anybody's learning anything new about her. I know more about Stormy Daniels than I ever care to know. And so I think victimizing her or making people feel like you're beating her up a little less tricky than if it were somebody like you dealt with. Okay. I got
Karen McDougal. Karen McDougal.
No Karen McDougal. What's the deal?
Oh, here's the deal. They will call Karen McDougal because I think they promised her in the opening.
No, they announced today they're not going to call her.
They're not going to do it.
Oh, this is news to me.
It just happened. Just before we got on the air. Just before we got on the air.
Is that good, bad? Doesn't matter.
I think that's a very wise choice for the prosecution. I think they got a ton of criticism for how they handled Stormy. And at the end of the day, it's not Karen McDougal, okay? It's Stormy Daniels. But they've already got in everything they need about Karen McDougal. Everything. They don't need her walking in with a nice dress and makeup and all. They don't need that. And to describe that she had an 8-month affair, I think that's already in through records. I could be wrong, but they may put in some documents that just shows that there was a relationship between her and Trump. I want to say this. After Stormy Daniels' testimony, I've been talking to a lot of people about that. I think there's a high likelihood that the jury thinks, yes, at times, Stormy Daniels is a pathological liar. But on that day, in that hotel room, on the day of that tryst, I believe something happened. The defense is drilling down, they're digging in, and they're taking a position it never happened. Here's what I want to know. Are they, the prosecutors, going to call any witnesses, 2 or 3, to corroborate that Stormy was in that room, and we don't know what happened inside, but she didn't go in to read the op-ed page of the New York Times. She went in there for a reason. And are they going to call witnesses to corroborate her story? Why do I mention this? Because in all the jury trials I had, whenever the defense was fighting a fact that was almost undisputed, or it was tough, in closing, they lose credibility. They lose credibility. So if they continue to say, it never happened, I think that's going to hurt Trump in the closing. I do.
Yeah, I think, Linda, I want you to ask the last question. I know we got to let Gene go because we could go on and on
stay.
and on. My question, and I think you're right, I think that's a Trump directive, perhaps.
I agree.
That he's had this, I never did it, I never did it, I never did that, and so he's having them die on that hill, and I do not think it's going to help him. I agree with you.
And all they got to say in closing is, members of the jury, Mr. Trump, is he a perfect human being? No.
Yeah, it's not illegal to have an affair. It's not illegal to pay somebody to shut up about it. Did he violate his marital oath?
Yes, he did. Did he sin, if you will? Yes, he did. Did he have a relationship with Karen McDougal and Stormy Daniels or an event? Yes, we're not fighting that. What we're fighting is this case is about those invoices, and can you connect them to the NDA between Stormy Daniels and Trump, and they didn't prove it beyond a reasonable doubt. That's why he's here. We don't care if he wore a condom. They threw that stuff in. Members of the jury, the prosecution threw that stuff in to embarrass Mr. Trump and to incite your passions and your emotions. But that is irrelevant to this case. I would go nuts.
Yeah, and you're right about agreeing, because, look, those of us who've lived in New York, when people say that he was the most eligible bachelor, that's where he was on all the newspapers for years. He was considered the most eligible bachelor. Everyone knew he was sleeping around. It was in the New York Post. It was in my friend Cindy Adams' column. It was everywhere about him. No, that doesn't surprise anybody. The only question But I have a question for you. What if one of the members of the jurors think, hey, if you paid a lawyer, no matter what it's for, you could put legal expenses down. That's it.
Well, here's the argument against that. I love food, as you know. I love food. I'm talking about a souffle. What is really going to hurt the defense is, I call it the souffle invoices. He didn't listen, there's a big difference between a reimbursement and a legal expense. Big difference. Big. And it goes back to that 2013 footnote 11 in that sentencing memo. If you reimburse Cohen for money that he had paid you for a poll or online, what you're saying is he contributed to my campaign and I'm giving his money back, but I still had to report it at some point. Okay? By making it a legal expense, you've laundered it, you've washed it. And the only way to do that is through the souffle. You had to give him $420 because Michael Cohen is a cheap SOB. And he said to Weisselberg, this is what he's going to say, hey, I gave $130, but when I get it back, if you call it a legal expense, I got to pay taxes on that $130. So you got to pay me for the taxes that I got to pay. That's why it was a souffle. And then they threw in a bonus, which is deductible. And then they threw in something else that he had paid. But the $130 that became a souffle, 2 times $130, I don't see how they're going to get around that one. No way.
So this is very nuanced, Gene. I think you would agree.
Yes.
And then in most complex business litigation, which is at
I did a ton of business cases.
I think the jury's just going to go numb. They're either going to...
I disagree.
I think they're going to latch onto the salaciousness, and I don't like Trump, and this just cements in my mind why I don't like him, guilty, versus, I'll bet you that money, when it was passed from A to B, really was meant to be C and D. Aha! I just don't give them that much credit. Sorry.
I disagree, and I'll tell you why. I did 30 tax cases. I had 110 total, and I wish I could say I won every one. But I had tax cases that are a ton of documents, and I am amazed at how jurors, at the end of the day, can encapsulate the core issues in a tax-related case. And this is basically a tax case in the guise of a election interference. But I'm telling you right now, those two attorneys on the panel, they get the souffle. They understand the souffle.
In any of those tax cases, did they talk about condoms or silk pajamas? Any of that stuff come up?
No, hold on, wait a minute. We had a tax case that was a little bit racy, but not as late. We didn't have a Stormy Daniels.
Okay.
So you said, Gene, that this is a tax case in the guise of an election interference. I think it's an election interference in the guise of a tax case. Is there a difference?
I guess I put the cart before the horse. Yeah.
Okay.
Yeah, there is a tax violation. By the way, there is a tax violation federal level. There is. Because on the returns, they carried that deduction onto the tax returns, I'm sure. That would be a federal violation, but a minor point. But, Michael, you're right. Of the 12 jurors, probably 3 or 4 are going to go, oh, my God, what's he talking about? What's that Rossi's talking about souffle? But the 2 attorneys, they will understand it completely.
So what's going to happen? Are we going to have some people getting put in a headlock there in the jury room?
I represented an oath keeper, and what happened was there was an attorney.
Tell people what an oath keeper is, so some people don't know.
An oath keeper was the one, they had the vests, and they entered the Capitol on the east side. There were 2 groups of 14, and I represented the first oath keeper in the U.S. Capitol on January 6th. Okay, so in that trial, one of our jurors was a DOJ attorney. You're saying, why'd you leave him on?
Right, that's what I'm saying.
Yeah, we ran out of bullets, and he knew me. He knew me.
That's challenges for those of us who don't know.
Linda, yeah. He knew me,
and he knew you.
He wasn't a dear friend, but he worked on the same floor as me. He knew me, and. We because we had 5 defendants. We had to come to agreements, but the other defendants wanted him on. Well, he it turns out
why? Wait! Why would anyone want a lawyer on their panel? I can see this. You just ran out of challenges.
We ran out of bullets.
Yeah, that's silver bullet, as we say. We always try to keep one.
We had so many others that were 20 times worse.
Yeah,
we had to get rid of. We had to use our bullets.
Yeah, sometimes the best of the worst.
The point is about the attorneys. Those attorneys will either get the souffle argument, or they're going to say they didn't prove the connection. Too attenuated. It's possible that they will say it's too attenuated, and which gets to Michael Cohen. He's the whole ball of wax.
Yeah, that's the guy I want to rely on.
Hey, okay, if you're in Trump, he was the guy you wanted to rely on.
I always say this case is not a battle of the experts; it's a battle of the liars.
Yes.
It's not quite the same. Okay,
absolutely.
Hey, Linda, we got to kick this guy loose, but we should pick this up again. To be continued. What do you think?
Gene, absolutely, Gene. You have hit it out of the park. Whether you're a left-hander, a right-hander.
Did you like footnote 11 in the sentencing memo? I'm
going to go read it. I'm going to go read it right now.
Yeah, it's pretty good, actually.
Gene, you're the best. Thank you so much.